Was the defendant stating anything at that time?
From my angle, I couldn't hear anything. No, the defendant was just walking away with a machete in his hand.
All right, now, with that machete, did the defendant do anything?
So when I arrived on scene and I set myself up, the defendant was just walking towards the rock, climbed on top of the rock, and with the bloody machete, just sort of stood and held it in his hand, and just sort of stood there and started speaking to himself.
Do you recall what he was saying?
I can't recall 100%. It wasn't of English language. I'm unsure of the origin, but he was just repeating it consistently to himself.
Okay. Now, did the defendant try and make an escape from you and other officers?
He did, yeah. So when other officers arrived on scene and we formed good arcs of fire in case he did try anything, we had an officer approach to get hands on to the suspect. The suspect was dropped to the floor. He was cuffed on the floor. When he stood back up, he attempted to make a break for it down the hill.
Okay. And were you one of the officers to pursue after the defendant?
I was not. No, I was one of the officers sorting out the scenescape and the evidence.
Okay. Now, what did you see on the scene?
So on the scene, we had some sort of circular symbol just in front of the rock. To the left on a pole, we had some sort of poster quoting Arnom's name. And then 360 around the scene, we had random items distributed. So personal belongings to Miss Levenstein, or random belongings such as weed and stuff like that. And then at the end of the rock was a weed plant.
I see. Now, are you at all familiar with that specific encampment in Toledo?
Not 100%. I'm not aware of the origins of the camp, no, but I'm aware of its presence and what it used to be.
Okay. Had you traveled there previous to this incident?
Um, Previous to this incident, no.
Okay. Now, I'd like for you to reference at this point Exhibit 7. If you could just describe what you see in Exhibit 7.
So in Exhibit 7, it's the search conducted by Enzo Deluca, specifically highlighted the ID of Dario Levenstein, the victim on the scene. We've got some weed, we've got some crack pipes, some poppy seeds, we've got two sharp objects, a knife and a machete, and some alcohol and some water.
Okay. Now, did you ever examine the victim?
I had a brief look over the victim while collecting evidence. Yeah, I had a quick brief look over, yeah.
Okay. And did you see any slash wounds on the victim?
With the victim being decapitated, I'd say so, yes. I'd say it'd be out of the bounds of physical strength to do that to someone with your hands. The victim was in quite a bad state when I looked over originally. She was just quite mauled up, quite cut up, yeah.
Did you notice any specific marks on the victim?
From the top of my memory, I can't recall.
Okay. Now, was the defendant ever brought back up to the scene after he was apprehended by officers?
Once he was apprehended, yeah, he was. So when he took his trip down the hill, he fell over and injured himself, so he was brought back up to the top to be dealt with by EMTs on scene. So yeah, he was brought back to the scene, back towards my cruiser, yeah.
Okay. Can you specifically recall the defendant having any sort of blood on his hands or mouth or anywhere in his person?
Yeah, so the defendant in his hands, the weapons on his person, and a little bit around his mouth and neck was bloody as well, yeah.
Okay. Now, after the scene, did you at all partake in the interrogation of the defendant?
No.
Okay. Were you at all a witness to the interrogation?
I was a minor witness, yeah. I had to swap in and out, yeah. I was partially there.
Okay. At any point, did you hear the defendant talking about the victim?
Yes.
Can you explain the context?
He explained that she was, from the top of my memory, chosen that he killed her, and that she was cursed in some kind of way.
No further questions, Your Honor.
The defense may cross-examine.
The defense will decline.
All right, Detective Denmark, you are excused. The prosecution may call its next witness.
Your Honor, the state calls Officer Fisher to the stand.
Hello, Officer Fisher. If you would face me. Raise both hands. Do you solemnly swear that the testimony you're about to give today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, you may take your station.
Hello there, Officer Fisher. How are you today?
Doing good, you?
I'm well, thank you. Now, again, I'd like you to reference Exhibit 1. If you could.
Yeah, wait for it.
Of course. Whenever you take a look, can you just say whether or not you are familiar with that exhibit, whether or not you've seen it?
Yes, that was the dispatch call that myself and Detective Arnom received while on patrol.
Okay. And did you respond to that call with Detective Arnom?
Yes, sir.
Okay. Now, when you arrived on scene, can you describe what you saw?
When we arrived on scene, like you already heard today, we arrived very late to the scene. I believe we were the last one to respond. LEO was. And when we arrived on scene, the first thing I noticed was the victim's body laying on the symbols mentioned, or the symbol mentioned, and the defendant who was surrounded by officers.
Now, you stated that the defendant was close to the victim, is that right?
I don't remember exact proximity when I got there.
Did you notice the defendant holding anything?
To my recollection, I do not remember if he was or was not.
Okay. Were you paying that well of attention?
I was, but I just couldn't tell if he was holding anything.
Of course. Now, do you recall the defendant trying to run away from officers, or did he
Yes, I
stay?
do remember him fleeing. Yes.
Okay. What happened when the defendant fled?
I do not believe I was a part of the ones that chased him. I can't remember, but I know I wasn't one of the ones that apprehended him.
Understood. Now, were you a witness to the interrogation of the defendant?
Partially, I didn't catch all of it.
Okay. Were you there for at least the majority of the interrogation?
Some of it, yeah.
Okay. Now, did you ever hear the defendant bringing up the victim in this case?
Just in the various ramblings of she was to be sacrificed, she was chosen to be sacrificed, or in some variation like that.
I see. Now, you had to drive up there, correct?
Yes, sir.
Okay. Would you say that it was an easy drive up there, or did it take some time?
Oh, it took some time. We were like Detective Arnom said, we were in Southside, all the way down below Olympic Freeway.
Okay. No further questions, right?
Defense, you may cross-examine.
The defense has no questions, Your Honor.
You are excused.
Thank you, sir.
Prosecution, you may call your next witness should you have one.
Your Honor, the state is not going to call any further witnesses.
Sorry, can you speak up a little bit? You're quite quiet.
Of course. The state has no further witnesses to call, Your Honor.
All right. Defense,
I would like to call my client to the stand, please.
Okay, Mr. DeLuca, under your Fifth Amendment right, you are not required to testify at your own trial. Are you aware of this, and do you wish to be on the stand?
I'm aware of my rights, and I'd like to proceed, Your Honor.
Okay.
Sir, if you would face me, raise both hands. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may take your station.
Mr. DeLuca, is it true that you were giving a mental evaluation after your arrest?
Yes.
Do you know the results of that evaluation?
From what I was told that the results are inconclusive.
So it can neither prove nor disprove any mental state and or question of the state.
Correct.
Okay, so I would like to talk about the one. The one was not chosen by you, was it, Mr. DeLuca?
It was not.
And what did choose it is in this room, is it not?
That is correct.
Now, if you would please tell the jury, is it in this room in its complete, or is it in this room in a partial matter?
And it's partial.
Now, I would like for the jury to recognize that under the time that the chosen one was chosen, it was not my client's decision to make.
Your Honor, objection. Counsel's testifying.
Yeah, we've already established testifying in court for the counsel. Mr. Wilkins, can you ask a question?
Sure. Mr. DeLuca, under the time of which the one was determined, did it cause you physical pain?
Immense.
At this time, could you feel burning? And if so, where?
Everywhere, really.
And you would say that this was indeed an intense pain that led you or helped guide you to do the actions that you did do.
Precisely.
All right, for the time being, the defense has no more questions, Your Honor.
Does the prosecution wish to cross-examine?
Yes, Your Honor. All right, now, Mr. DeLuca,
Sir,
are you actively testifying right now under oath?
I am.
Are you currently standing trial?
I believe so.
Okay. Did you ever speak with a doctor and have that doctor tell you that you were incompetent to stand trial?
I was never in contact with a doctor, but with the person I spoke with, they did make sure to tell me that they were a registered mental health, I don't know the word I'm trying to look for, professional, I guess.
Okay. Now, what's that individual's name?
It's gonna be paramedic Natalie Carson.
Okay, paramedic Carson. Did they ever state to you that you were unfit to stand trial?
They did not.
Did they ever state to you that you were insane at the time of the commission of the crime, or in your current state when you were being evaluated?
They did not.
Okay. Now, I'd like to go to what you testified to. The one, is it?
Yep.
Okay. What is the one?
Bigger than anything any of us could be.
Is this a person, or is this a moral compass?
I guess you could call it as the figure of overall omnipotence.
Huh?
A god?
Somewhat.
So that
Are
man is
there any other
crazy.
individuals that you know of that believe in this god?
There are many.
Many. Okay. Can you name a few?
I will not.
Your Honor, if you could instruct this witness to answer the question, that'd be appreciated.
No objection, Your Honor. Relevance.
Your Honor, overall, when the state is of course, questioning a defendant on trial, the scope is very broad in terms of what the questions can be about.
Ask.
This all-seeing eye, moral compass, God, has been brought up a multitude of times during trial and is quite relevant to know who may be involved.
Your Honor, we are on trial for a specific murder. I do not believe knowing the names of other people who have shared in this religion is relevant at all.
Well, one more, Your Honor. This, of course, all goes to the credibility of the statements.
All right. I'm going to sustain the objection. Please entertain my question.
Of course. Now, Mr. DeLuca, what was your relationship to your victim, Miss Levinstein?
I knew nothing about her.
How did you come in contact with her?
I found her in Polito. And that's about it.
So you found her in Polito, and then what happened in Polito? Did you receive a sign?
Yeah.
Okay. Did that sign? What form did it take?
Kind of like a sixth sense, like your body moves before your brain moves, sort of thing.
Oh, and at that point, you could feel it. You had to take Miss Levinstein.
Correct.
Okay. And I'd imagine, where exactly in Polito were you located?
It was outside of the clothing shop. I don't remember what street that was. I believe it might have been Polito Boulevard.
Okay. So you were at the clothing store in Polito Boulevard. Then, did you lure her in on your bike?
I asked her to follow me
Okay. And where did you lead her?
to the nudist camp of the Chiliad State Wilderness.
Okay. Did you have any weapons on you at the time?
I did. I had a combat knife and I had a machete as well.
Okay. I'd imagine it took you, what, like maybe 10, 15 minutes to walk up there?
No, she had stolen a motocross bike, and I drove my motorcycle.
Okay. So you both drove up there. How long did it take you?
Nothing more than a few minutes.
A few minutes from this clothing store to an encampment up in the woods.
Mm-hmm.
What happens when you both get there?
Well, I basically tell her that he's watching, you know, and he needs what he needs.
At that point, you killed her, didn't you?
That is correct.
Now, why did you do that?
It wasn't out of my own self-consciousness. It was out of, I guess you would call it, like I said before, the body acting before the brain.
I'm not sure I quite understand. So, you, the person, your body killed her.
Correct.
any of her limbs?
From what I remember, yes.
Okay. Did she at all struggle or try and get away?
No.
Okay. Now, did you at all try and consume her body?
Not that I recall. But like I said, it was my body acting, not my head.
Again, sir, this is you we're talking about, correct?
Correct.
Okay. So, do you recall officers showing up to the scene?
Yes, I do.
What happened when they showed up?
Well, I was held at gunpoint by the detective who kind of looks like not the detective, it was the sheriff at the time who looked like a rip-off Hulk Hogan. He held me at gunpoint and waited for other officers to come to the scene.
Let's see. Did you at all try and run away?
Not until after the fact that more officers showed up.
Why is that?
It activated my fight or flight response.
So it activated it a minute after police officers got there?
When more started to arrive is when it slowly became worse and worse.
Okay, and you were fearing the police, right?
Correct.
You were fearing going to jail for your actions, right?
Correct.
Okay. Now, I'd like to go ahead and talk about you. You were earlier testifying to pain, is that right?
That is correct.
Now, was any of that ever brought up in the psychological evaluation that was performed by Miss, was it Clarkson?
It was not brought up because it wasn't a physical examination, it was a mental examination.
Okay, do you, or have you, ever been burned on second, third degree burns?
Well, for some reason, I have scars of letters all over my body now.
That didn't necessarily answer the question. Have you ever gone to the hospital for second or third degree burns?
I have not.
Okay. Now, again, I'd like to go back to the actual scene of the crime. Now, is it true that you had a knife on your person?
That is true.
Is it true that you had a machete on your person?
That is true.
Now, around how long to when you and Miss Levenstein, your couple-minute drive up to the encampment, to when you killed her?
I'm sorry, could you repeat the question?
Of course. Now, from around how long from when you and Miss Levenstein drove up to the encampment to when you killed her?
It was about 45 minutes.
Okay. No further questions at this time, right?
Does the defense wish to recall?
I do. Mr. DeLuca,
Sir?
religion can be a funny thing. Does yours offer you something in an afterlife?
It offers precisely that.
Fair enough. So
The life after death.
one could say that you acted sheerly, as most humans have throughout all of human history, and you know, acted on those beliefs.
That is correct.
Not uncommon. Returning to the eye. One moment, I want to figure out how I want to phrase this exactly. In referring to the eye, does the eye itself make the decisions and instantly you lose the mental aspect of your body's actions?
That is correct.
So it is instantaneous.
Precisely.
Okay. Now, at what time do you start to come back into your own mental standing?
It all depends. Depends on what actions happen beforehand. Because, of course, I'm sure you know the body can only undergo so much physical duress before it shuts down.
This is true. This is true. Okay. So there's quite a few miscellaneous attributes that can cause the overall sway to go one way or another for a longer period of time, correct?
Correct.
Fair enough. So, Mr. DeLuca, this eye, has it always been with you, or is it a relatively new addition?
It's always been with me.
Since birth?
Yep. It's always been there. It's never gone away.
Okay, and did any family members, by chance, also inherit this?
Not to my knowledge.
All right. I have no further questions, Your Honor. Thank you, Mr. DeLuca.
All right. Mr. DeLuca, you are excused.
Thank you, Your Honor.
Does the defense have any further witness?
The defense does not, Your Honor. Your Honor, may I approach?
Yeah, both counsels can approach. So stand over here. All right, before we get to closing statements, we are going to take a 2-moment recess because we have been here for a while. So if anyone needs a bathroom break or stretch your leg or a drink of water, make sure that, be back here in 2 minutes.
How long?
Closing
It's
recess.
10 or 2?
2.
2. Thank you, Your Honor.
Two of you ready to proceed once the defendant is back in his seat? Yes, sir.
Right, sounds good.
I also do Instacart too. That's actually a super time saver.
Never heard of it. Sounds like Instagram, and I don't like Instagram.
No, Instacart is just DoorDash but for groceries. Yeah.
Here we go.
Of course, my chair. Oh, ouch.
All good, 109.
Yeah, I'm gonna switch over tax
not
until
gonna lie, I
Dagger.
thought the guy
Whoa.
was
Buddy.
Whoa.
Whoa, whoa.
Whoa.
Magician.
What are we lowing?
Oh,
What are we
man.
lowing for?
Once I get everything back in his session.
Can we make a sign saying no magic allowed in the courtroom?
That's good.
He just walking through walls.
Didn't hear you. Who's that?
All rise. The Superior Court of San Andreas is now back in session. The Honorable Chief Justice Thomas Fudge still presiding.
Calling back into session the case of the State of San Andreas versus Enzo Deluca. Can we get Mr. Deluca uncuffed again?
I got you there. That's my baddie.
Thank you, Bert.
Here you go.
Okay. Both prosecution and the defense have rested their cases. Members of the jury, you will now hear the summations from the attorneys. Following these summations, I will instruct you on the law, and then you will begin your deliberation. Prosecution, you may begin with your closing statement.
Thank you, Arnom.
Oh, my God.
Now, Your Honor, ladies and gentlemen of the jury, as we have learned in this case, the witness testimony, photographic evidence, interrogations submitted, and even the defendant himself, there's overwhelming evidence to show the defendant is guilty beyond a reasonable doubt of the first-degree felony murder of Dorothy Levenstein. Now, I'd like to recap much of what we have actually heard in this trial. Now, first off, we have heard the defendant is actually fit to stand trial. There hasn't been any sort of diagnosis nor any other documentation from a doctor stating that the defendant is either unfit to stand trial or that he was legally insane at the time of the crime. Now, without this, you should not take any sort of these thoughts of insanity or whether or not he is competent to stand trial when deliberating. You should treat the defendant as he is determined to be fit to stand trial, because that is the case. The fact is, this trial even happening should reassure you of his fitness to stand trial. We wouldn't be having it if that was not the case. Now, further through this trial, we've heard how the defendant intentionally premeditated the murder of his victim, Dorothy Levenstein. We heard how the defendant admitted both under interrogation, first that being Exhibit 6, as well as the testimony from the defendant in this courtroom that he murdered the victim, that he himself, that any sort of assistance, aid, comfort, nor any sort of coercion, murdered his victim. He cut her body into pieces, and then he tried to consume them. We heard this from both officer testimony along with the defendant's testimony, how he chose his victim. He deliberately found his victim, convinced her to join him in the Paleo Bay encampment, drove with her for 45 minutes up to the scene, and then he murdered her and sliced her body, her limbs, her head, even ate parts of her body. After all of that, he then called 311 to boast about what he did. Now, as stated by the defendant under oath, the defendant, as soon as he saw his victim, had an urge to kill her. He then took 45 minutes to formulate and execute his plan, his victim's murder. Now, of course, with all of these circumstances in mind, we have learned beyond a reasonable doubt that the defendant had premeditated intent to kill his victim. As was stated in the state's opening statement, premeditation is not simply a year, month, or even a day-long cultivation. Premeditation can take minutes, which is exactly what we have in this case. As soon as the defendant saw his victim, he chose her. From that point forward, all of his actions are then executing his mental plan to murder her. Through the 45 minutes to her death, he had every opportunity to stop what he was doing, yet he did not. He did so of his own free will, not as he claims to be a demon to have guided him. Now, again, can't stress this enough. This crime itself, heinous and vicious in nature. was done out of the defendant's own selfishness to quote unquote satisfy a quote unquote God. Now, again, this is simply more evidence overall to show the intention and the premeditation of the defendant. The person knew from his religion that he was going to need a human sacrifice. We learned how he got his urge to kill the victim, and then he did so. So many opportunities in between to stop his actions, to think, to stop his plan in his tracks, yet he didn't. He continued to carry out his plan until it was done, until Miss Levenstein was dead. Now, the state asks, ladies and gentlemen of the jury, to make the right choice. A choice that is backed up by evidence and the truth. To adjudicate the defendant guilty in the murder of Dorothy Levenstein. Thank you.
The defense may proceed with their closing statement.
Ladies and gentlemen of the jury, we have been through quite the case today, and some of the details of this case are rather gruesome in nature. And it is true, the witness was not shown to be unfit for trial. However, the testimony does show that his mental process was compromised and can be compromised in the future. The planning of the killing of the victim did not happen. It was an impulse. This is from direct testimony from a man who physically butchered this lady. I believe if he was going to lie about something, I believe it would have been about the murder itself. These impulses are unknown in nature. We do not know the potency of the impulses or the pain there within. But I ask you to judge this man fairly based off of the evidence as well as the testimony given by all parties. Thank you.
Members of the jury, at this point you have heard all of the testimony around this case, and it is now up to you to determine the facts. You and you alone are the judges of the fact in this case, and once you decide what facts the evidence proves, you must then apply the law as I'm about to give it to you as you find it. The law in this case is as follows. First degree felony murder. Directly or indirectly causing the death of a person with premeditated intent. And finally, I will outline the process of the deliberation. It's not my responsibility here to judge the evidence, it's yours. You and you alone are responsible for deciding whether the defendant is guilty or not guilty. And what you have to remember is that you have promised to be a fair juror, and a fair juror is a person who will not permit their verdict to be influenced by any sort of bias or prejudice in favor of or against the defendant that appeared in trial. In your deliberations, you must also not consider or speculate about matters relating to sentence or punishment. If there is a verdict of guilty, it will then be my responsibility as the judge to impose an appropriate sentence, so do not take any potential sentence or punishment into consideration when debating on the facts. When you do judge the facts, you are only to consider the evidence. Throughout these proceedings, the defendant is presumed to be innocent. As a result, you must find the defendant not guilty unless the evidence presented at this trial concludes to you that the state has proven the defendant guilty beyond a reasonable doubt. The verdict you come to as the jury, whether that is not guilty or guilty, must be unanimous. That means that each and every juror has to agree to it. And when you deliberate, you should do it with a view towards reaching an agreement if that can be done without surrendering your individual judgment. When the jury has reached the verdict, you'll be asked to come back into the court, and the foreperson will be asked whether the jury has reached a verdict. If the foreperson says yes, then they will be asked what the verdict is for each crime charged. In this case, there is only one. And finally, there are just a couple of rules that you must observe during your deliberation. While you are here in this courthouse deliberating on the case, you will be kept together in the jury room. You must not leave the jury room during deliberations at all. If you have a cell phone on you, you must hand that to a member of the court staff before entering that room. You can only deliberate the case once you are all gathered in the room. You cannot discuss it while moving from this courtroom to the jury room. Only discuss it in that room. During your deliberations, you can only discuss this case with yourself. You cannot discuss it with anyone else, including a member of the court. If at any point during deliberations a juror wishes to speak to me, then an appropriate meeting can be held here in the courtroom with the parties involved. No juror, however, can tell me what is being said about the facts of the case, a possible verdict, or what anyone is intending to vote, or any count of voting. And I can, of course, listen to what the juror has to ask, but it can only be about the instruction of the law as it is written. It cannot be about anything else. With that being said, the court staff will escort the jury to the jury room, and at this point, this court is in recess.
Frank, does this guy have a tie on? No, wait.
Careful.
Does this guy have his button up all the way up to the top without a tie on? Terrorists.
Wait, me or them?
No,
Uh,
you're both surrounded by terrorists.
This medical report a pain in the ass.
Make sure it's written.
I am writing it.
Prosecutor all the way. Fudge. He's fantastic. Until the jury.
Justice Thomas Fudge still presiding.
All right, calling back into session the case of the State of San Andreas versus Enzo Deluca. Will the jury foreperson please stand? However, I see they're all stand. Has the jury reached a unanimous verdict?
Yes, sir.
On the one count of first-degree felony murder, how do you find the defendant?
Maybe you could see
The
it.
jury on the one count of first-degree felony murder has decided the defendant is guilty.
All right. The jury is thanked and excused. Okay, we now proceed to sentencing. We have two options for sentencing. We can proceed to sentencing now, or we can reschedule sentencing for tomorrow. I will allow the both councils to confer what is more amicable for those. Because I am aware that people have been here for a very long time.
Did Mr. Hall say anything?
Prosecutor Hall, or are you okay?
Oh my god.
Mr. Hall, are you with? Can anybody hear Mr. Hall?
I cannot.
Yeah, I
No,
can.
sir.
Negative.
No, I can't.
Negative.
Oh, hello?
Oh,
There
yeah.
we go.
Oh, I can hear him now.
Hey, quiet.
Not hear anyone.
All right. So
Pickles.
okay, so the jury have found the defendant guilty. Now the next step is sentence, and we can either proceed with that this evening, or we can reschedule it for tomorrow. By letting both counsels confer and come to an agreement on when that is, because I do understand that at this point people have been here, some people for about 5 hours.
Your Honor, the state's prepared to make a quick sentencing recommendation. However, open to your waiting or the other plan.
Okay, so we will proceed to sentence.
Your Honor, as has been shown through the evidence, this truly at heart was a heinous crime. It involves the brutal murder, dismemberment, and cannibalism of the defendant's victim, Miss Levenstein. Now, this is a murder that was planned, that was carried out, again, so brutally, as has been described through the evidence. Now, the state feels there is no other fitting sentence other than for the defendant to be sentenced to death.
Defense? Mr. Wilkins, would you like to make a statement, recommendation for sentencing?
Your Honor, some of the things that happened in this case are truthfully, I can't fathom. And to be fair, I don't think anyone here really can. Some of these things are out of this world, and to try to pretend that we understand them can be a little hasteful. I do not think that my client should be put to death by any means. No, I do not see that. But I have no counsel on what the sentencing should be, Your Honor.
Mr. DeLuca, you do have the right to address the court prior to a sentence being imposed on you. You're not required to say anything if that's what you choose to do, but the law does afford you the right and opportunity to address the court. Is there anything you wish to say?
Yes, I would like to say something.
Okay. We address the
Your Honor, ladies and gentlemen of the court, I would also like to please point out that I have been in Bolingbroke for roughly 30 years, already serving the sentence. I'm kind of tired of being kicked in the showers every night, and it's not great. That is all. I'd like to go home.
Okay. We will take a short recess of around 5 to 10 minutes to make a ruling on sentence, and then we will reconvene. Where is in recess?
Thanks for the nightmare hallway.
All right, all rise. The Superior Court of San Andreas is back in session. Honorable Chief Justice Thomas Fudge still presiding.
Mr. DeLuca, you were found guilty of first-degree felony murder. And now we have to impose sentence. In this case, it has been very interesting and very difficult, especially for us deliberating on a sentence to impose a sentence that matches the crime and everything encompassed. And so I'm going to impose the following. Mr. DeLuca, you will be sentenced to life in prison in Bolingbroke Penitentiary. You will be protected by what is known as Lanterman Petrol. Now, this means that there are procedural safeguards to ensure that should your mental health deteriorate, you will not be unfairly or unjustly held against, your will while you're in. You will be eligible for parole after 50 years, provided that there are no incidents during your time in Bolingbroke, and provided that you are cleared as mentally sane from a certified mental health expert from the LSFD. Secondly, you will pay a fine of $15,000 to the state. Thirdly, if you are granted parole, that will be the result of a parole hearing. Now, that will take place in front of a neutral judge. That would not be myself. And the warden of the San Andreas Department of Corrections and Rehabilitation. And in that hearing, if parole is granted, any special terms would be set out in that. With that being said, you do have the right to appeal both the verdict and the sentence. Given the nature of the crimes, you will be granted a period of 14 days to make that appeal. If that appeal does go through, it will then go to a panel of justices, given that the jury delivered the verdict and I was the presiding judge. I would not be able to sit on that appeal, but that option is open too. With that being said, this court will stand adjourned.